Yes, Kirby.
My lords, my lady, it I hope is clear from the skeleton argument on behalf of the child that we would say that Mrs Justice Lieven's judgment was a paradigm judgment and remains so. We say that she identified correctly that she had the jurisdiction to make the order that she did for the child to be brought to this jurisdiction. She then went on to consider whether the test that was developed in Riem by this court, when applied to the facts of this case, was satisfied, and she found that it was. And she went further and considered the apparent conflict between what Miss Justice Henke said in Re D and what she was doing in this case. But when she did that, considered Re D, she identified, as I think the court has identified this morning, that Miss Justice Henke accepted, on the one hand, that she had jurisdiction to make the order, but then on the other, she, on those facts, decided not to exercise that jurisdiction. But it is right that at some points in Miss Justice Henke's judgment, she seemed to suggest that there was a cutting across of the statutory jurisdiction, and we would say that it is clear that an order such as the one made by Mrs Justice Lieven in this case can be made, because it is the same order in effect as was made at first instance by Mr Justice Peter Jackson in A&A. What Mrs Justice Lieven then went on to do, and we suggest should be something that is worthy of commendation, is that she considered in a very balanced way the arguments in favour of making the order sought and against making the order sought. And when she had completed that exercise, she was clear that the balance was in favour of exercising the power that she had to invoke the inherent jurisdiction. At paragraph 83 of the judgment, then, having gone through those stages, she reaches very clear conclusions, and she provides the reasons why she reached those conclusions. So when you look at the judgment as a whole, it really is a paradigm judgment, identifying the jurisdiction and then going on to identify what test she had to apply on whether to exercise the jurisdiction, and finding on the facts of this case that there were compelling circumstances in this case. It is not the case that we criticise the test that was come to, developed, enunciated in Riem. In fact, I hope that it's very clear from paragraph 68 that we say of our skeleton. Mr Rowley took you to it earlier, suggesting that it was a critique of the judgment in Riem. We didn't in any way seek to criticise that, and in fact we would defend the test that was enunciated in Riem, because all it was doing in effect was bringing together lots and lots of comments that had been made over many years at high levels of court, but it made it clearer, we say, to say compelling circumstances on the facts of any given case. So when one looks at where the test comes from, the beginning of it really, well, the beginning predates A&A by quite a long...
1854.
Yes, well before A&A. But without looking at those judgments from before A&A, there's a good summary in A&A of the jurisdiction not having been killed off by the 1986 Act. And when Lady Hale and Lord Hughes both refer to, I don't know whether it's helpful to look at what they say in A&A talking about the nationality jurisdiction. It's really at 41 where Lady Hale deals with it from paragraph 59. And she surveys over the open hope, etc. And she comes down to, when she talks about how high a test it is, we see that she specifically disapproved of Lord Justice Macfarlane, as he then was, commenting, if this is at paragraph 62, the end of paragraph 62 on page 42, that when he had said, if the jurisdiction exists in the manner described by Hogg J, then it exists in cases which are at the very extreme end of the spectrum. That's something that Lady Hale and later Lord Hughes disapproves of. And these are all the origins of why in Riem it was helpful to put compelling circumstances as the test going forward, because it summarises and finds a few words to convey what is needed in order for the inherent jurisdiction to be invoked in the way that Mrs Justice Lieven did it in this case. But when one looks at it might be helpful to look back at A&A and the argument between Mr Turner, King's Counsel, and Mr Setright, and Mr Gill, in fact, because when it's set out in the full report as to what arguments were being made, Mr Setright was arguing on behalf of the father that the jurisdiction had been killed off, in effect, by the 1986 Act. And Mr Turner was saying, no, it's still there, it survived, and this order for a return that Peter Jackson, Mr Justice, then had made was within the bounds of what was permissible. And we find, having gone through the different arguments, that Mr Setright and Mr Gill, on behalf of the father, when saying, you can't possibly say that an order like this, in that case we remember it was a child had never been in England, born in Pakistan, and the court was saying, well, Mr Setright and Mr Gill were saying you can't do that, and comity was their main argument, but also saying that Section 1 and Section 2 of the Family Law Act meant that it wasn't possible to make a return order. So there is no doubt that the Supreme Court had those arguments articulated by Mr Setright and Mr Gill, but they preferred Mr Turner in his argument that you could make the order that Mr Justice Peter Jackson had made in that case. And she says it in plain terms in paragraph 27 of A&A. 28, sorry. So having rehearsed their various arguments, she says, the order made by Peter Jackson J and repeated by Parker J fell neither within Section 11A or Section 11D of the 1986 Act, and was therefore not covered by the jurisdictional prohibitions in Section 2 of that Act. Now, this morning, it was suggested that maybe talking about cutting across the statutory jurisdiction is unhelpful, or might be helpful, and we say it wouldn't be helpful to say that that's any part of the discretion, because we say that the Supreme Court, and Lady Hale there makes clear that that order of a child being brought to England does not offend against Section 1 and 2 of the Family Law Act. And therefore, if one thinks about would it be helpful to say sometimes it might cut across the statutory jurisdiction, we say no, it wouldn't. But what might be a factor that could be enunciated to bring in the idea of the motivation for making an application, it might be something like what will happen next is a factor. So in this case, the local authority had said, we will bring public law proceedings, we will be issuing care proceedings. And that's fine, because given the history in this case, they almost are compelled to bring public law proceedings on her return if they're to abide by their statutory duties. But in my submission, that paragraph 28 makes clear that in the right circumstances, if an order like this is made, then it doesn't cut across the...
Well, what paragraph 28 says is either, if you're covered by the jurisdictional prohibitions, of course you can't make the order, but if you're not, you aren't.
Yes.
When you can, whatever, I can't remember which way around I was doing it. But, yes, I understand that. Are you going to anywhere else in A&A?
Where would you like me to go?
No, I wasn't asking you to go in. I just because I wanted to go on. I don't want to take you out of order, but I assumed you were next coming to Re B. No.
But I was going to go straight to M and go back to B, but I can do it in whichever order.
Because so I think, as you say, that the idea of orders somehow conflicting with or cutting across, whatever expression you want to use, the jurisdictional prohibitions wasn't mentioned at all in A&A. In Re B, we have, if you're looking at the observations, and I appreciate they're all obiter, but one starts with Lord Wilson, with whom Baroness Hale and Lord Tilson agree, what he says in paragraph 53. And he agrees with the reasons advanced by Baroness Hale in their judgment, the three factors you need to take. These are three reasons why you need to be circumspect, and three reasons why you have to have quite a substantial, whatever the right word is, threshold. But he raises another factor. The most problematic question arises. The question would be whether in such circumstances an order for her return would improperly have subverted Parliament's intention. Now, do we ignore that? Or do we, or what do you think that means?
He's recognising it as a potential problem depending on the facts of future cases,
right,
but not arising in this case.
Right.
So he recognises that there is a potential in certain cases, I accept that, for the wrong circumstances to be used as a potential basis for an application under the inherent jurisdiction. But the reason it's not hugely helpful to go on from there is because he doesn't answer the question. He doesn't answer the question. He raises the question. He raises it.
And he leaves it hanging there.
He does. Obiter. Well, because they decided it on habitual residence, as you know, it's all obiter, and then we move on to Lord Sumption and obiter
and dissenting.
But as far as I recognise that as a recognition on the part of Wilson, Lord Wilson, that it could be open to abuse. But if the test that your lordships set out in Re-M is applied properly, then it shouldn't be open to abuse, because.
But would you accept that? I mean, what is a relevant question that the court may have to consider, depending on the circumstances of the case, is whether the circumstances are such that an order would improperly subvert, circumvent. Is that a relevant factor?
No, I don't think so, because if you're applying the test properly using compelling circumstances, what is going to happen next? That's why I think it's unhelpful to say it might cut across the scheme, because if it does cut across the scheme, then it's not a permissible order under sections 1 and 2 of the Family Law Act. if it's compelling circumstances, I respectfully agree that there needs to be development of what kind of factors, if the court can't trust a first instance judge to decide what the factors are in any given case. But it looks from the two that we have so far, Miss Justice Henke's and Mrs Justice Lieven, that they've been faced with an inappropriate use of it and an appropriate use.
So it's not. Do you think, is it your case that the discussion in this case in REB and then subsequent discussions may have inadvertently been unhelpful?
I think so. Yes. I don't think. I think that in REM, which I wanted to come on to in a minute, but in that case, what really happened in my submission and is clear from the judgment when you go back into it, is that the judge was overturned for reaching an unreasonable conclusion, and that is on the evidence, because his judgment didn't set out all of the evidence that he had heard. So it really was an overturning of his use of his own discretion as an inappropriate use. That on the facts, that's what that was about, and my Lord's judgment sets that out quite clearly. I would say that it was on the facts, because His Honour Judge Moradifer hadn't enunciated the reasons why he found this was an appropriate use on those facts of the inherent jurisdiction. But in the two cases, that the one that's relied on by the appellant, Miss Justice Henke accepts the jurisdiction,
Yes.
but then it's a totally different situation on the ground, because the
Judge
father...
Moradifer hadn't even addressed the question of section of the 86 Act.
Well, he didn't put it in his judgment, yes, so therefore nobody knew whether he had addressed it or not. But what he, I think, did mention was A&A allowed the order to be made, but he didn't justify his decision in the way that Mrs Justice Lieven does here. And I'm not sure that when you look at the factors that the Supreme Court have given us in A&A, they're a bit too case specific to have any general applicability, and that arguably may have been on purpose. That when Lady Hale goes through the factors to be considered by Mrs Justice Parker when the case is remitted to her, they're very specific. They're about whether the mother could litigate in Pakistan and whether she should have to go back, etc. Equally, the factors that Mrs Justice Lieven uses in her judgment are very case specific, even more case specific in a way, because she goes through all the reasons for making the order, the reasons against making the order. And maybe that is the way for a judge that's faced with one of these applications to be able to justify why they make the decision they do to invoke or not to invoke.
So going back to Lord Wilson's questions at the end of 53, which my part, I think this may be the key point. What do you submit to be the answer? Is the answer, it depends on the circumstances in each case?
Completely.
So that's what he's saying. He's saying the question is, in each case, whether the circumstances amount to an improper subversion of Parliament's intention.
Well, I'm not sure I understood you to agree that the subversion point was a test or relevant at all.
No, I wasn't agreeing that subversion was a test. I was saying that it should be on the facts of each case, left to the judge's discretion.
Yes, but could those, I suppose what I'm trying to understand is whether those facts might include this issue, or do we take what Lord Wilson's question is now answered by Rhea?
Yes, that the test of compelling circumstances must be individual to each case, and that if you want to take into account whether there are going to be care proceedings later on, or whether there's going to be private law litigation, or whether the child is going to be placed in local authority care by consent, all of that would be going into the facts of any given case. But to raise the idea that in certain circumstances there is going to be an attempt at an abuse of the process, I don't think is helpful as a test. And therefore, I suppose I'm saying that Lord Wilson's question doesn't need to be answered, because Riem goes on to develop it further by saying it has to be compelling circumstances.
I suppose, just trying to approach it another way, you would presumably accept that the relevant factors in this case included the attitude of the Thai authorities.
It was. She
Yeah.
said that, didn't she, at the end? That she's
But
aware of it.
You're saying that that's an appropriate, presumably saying that's an appropriate factor
It must
to
be.
take into account.
My lady, yes, it must be, because when you go back to the brass tacks of A&A, the three reasons that are enunciated are very clearly international respect, comity, etc. And I know that in Riem, the court didn't accept that those were enough and went on to consider other circumstances as well. But if you go back to the basic reasons in A&A why the Supreme Court wasn't worried about the use of the inherent jurisdiction, and my lady, that's why I was mentioning Mr. Gill, Queen's Counsel, being brought in as the specialist on international issues, etc. It was about, that's where their focus was. So when the Supreme Court said three reasons, they were all based on that. And Mrs Justice Lieven was very aware of those as factors. And she was right to specifically mention the Thai authorities and the fact that they were agreeing and there was no offence being taken or issue raised. And of course, in other cases, perhaps there would have been advice, specialist expert advice available from a Thai lawyer, etc. But because the local authority wanted to act quickly, it was done on a very much a summary basis, but on a non-controversial basis from the foreign jurisdiction's point of view. In terms of just finishing on the origins of where
It's quite a robust thing just to discard an observation by Lord Wilson as misguided.
Oh, I'm absolutely not saying that.
Especially when the Baroness Helen and Lord Wilson seem to, they refer to the fact that he's listed a number of important issues, which that question would have given, we must wait for another day. So they don't say we don't agree, so it's, but what I'm trying to work through speaking for myself, in my own mind, what he might have had in mind. In other words, when might an order for return improperly subvert Parliament's intention?
My lord, I don't know, obviously,
You can't think
I'm just to go back to the point about dismissing Lord Wilson or any surmising that he may have done in this judgment. I absolutely am not dismissing it. All I'm saying is that to the extent that it needed to be developed, the test in Riem developed it by bringing together the past authorities and summarising them as compelling circumstances and emphasising compelling. It's a high threshold, and perhaps that dealt with Lord Wilson's concern that it couldn't just be willy-nilly using the inherent jurisdiction to return children who weren't habitually resident in this jurisdiction. So if one thinks about what he might have had in mind, this was a private law application, and one can imagine any number of situations where a parent left behind might make an application to use the inherent jurisdiction when it wasn't an appropriate use of it. I'm not sure that he had in mind, and I wouldn't have thought that he would have in mind, for example, this situation where a local authority with legitimate concerns, Mrs.
You mean if the circumstances are sufficiently compelling, then you can't then resort to the statutory limitations to say, but because of these statutory limitations, they are not in fact compelling circumstances. So it's not very well expressed.
Yes.
But it's the sufficiently compelling which answers, and that's one of the issues that's arisen in this case, is that if the circumstances are sufficiently compelling in the eyes of the local authorities to justify the exercise, or to justify seeking the exercise by the court of its jurisdiction, the court agrees, then how does the statutory framework fit with that at all? Because why is it that you're suddenly saying, well, actually the purpose is to enable this court then to exercise its substantive jurisdiction? But yes, but why does that mean the circumstances are, how are you balancing it against compelling circumstances?
Isn't the test, first of all, is section 100, whether they should be allowed to invoke the jurisdiction?
Yes.
So there's a safeguard there to say you can't use the jurisdiction unless the court gives you permission.
Yes.
So for a local authority to come in with no real grounds, then it's at that stage that the court could say, no, you can't use it. And then there's a second stage, which in this case we dealt with in an all-in-one hearing, where the court looks again to see, is that a proper use? You almost have a review within the process already between the permission to use section 100 and apply to invoke it, and then the second stage of the actual hearing. So they should be filtered out if they're without merit, whether a public law application or a private law. If the facts aren't good enough, they shouldn't be good enough. And the compelling reasons is sufficient as a test on the facts of any given case. But the trouble with maintaining that you might, despite what A&A says, you might be able to say, actually, in these facts, on this case, it is cutting across the statutory jurisdiction. That leads to the kind of confusion that led to this appeal in my submission.
Would you mind if we parked cutting across and used Lord Wilson's phrase? I'm still not entirely clear
I'll have to write it down.
what you're submitting about this.
Right.
He says the question would be whether in such circumstances an order would improperly subvert Parliament's intentions. That's the phrase he used. So he's envisaging certain cases in which the circumstances amount to an improper subversion or attempt to subvert. What is your case about what that means, and how should a first instance judge approach that question when dealing with these applications?
The first thing, what did he mean by that? I think he was talking about facts where somebody would be trying to use the inherent jurisdiction when there was a perfectly fine remedy available under the Children Act, either a local authority or a private individual, trying to use the inherent jurisdiction and in effect abuse the process of the inherent jurisdiction. For what it's worth, I think those are the sorts of situations that he was talking about. And the second part of the question,
well, how does it balance? How is it then balanced with the other, with the compelling circumstances?
because, well, Lord Wilson was part, wasn't he, of the constitution of the court in A&A. So we're looking at what he says in a by the way in Re B. But in A&A, he said you can have a return order, you can convey a child in the right circumstances, and they found in that case that they were the right circumstances, or the first instance judge had found they were the right circumstances. But in terms of how that fits with compelling circumstances, I am submitting that that's the answer, is for each individual application to be decided on the basis of the facts that are asserted. So in this case, there were certain facts asserted. In another case, they mightn't have been good enough. So for example, if this local authority had only evidence of these parents being involved in a pre-birth conference, and there wasn't a long history of children being removed from their care, and they applied in the same circumstances, so the mother and father had left when the mother was pregnant, and they then tried to invoke the inherent jurisdiction to have the child brought back to England, then a court would say no, presumably, because there weren't facts found. They were exercising their parental responsibility in deciding before the birth. Well, they were exercising free will and without any legal obstacle in moving out of the jurisdiction to prevent the child protection procedures coming into play. In those circumstances, if this local authority had made an application under the inherent jurisdiction and Mrs Justice Lieven considered it, I am certain that there wouldn't have been an order for the child to be brought back here. So those kind of circumstances would be dealt with by applying the test in Riem.
One factor not to lose sight of is that these cases, A and B and M, were private cases. And I'm just thinking aloud here, might it be said that the question of subverting the subverting the intention.
The will of
The intention clearly it clearly fits into the wording of 1D. If what's going on here is giving care of the child to one of the parents.
Yes. But that's not what's happening here.
That's not what's happening here.
So you're not subverting the will of Parliament. The Parliament, when they passed the 86 Act, they carved out, as the Supreme Court recognises, they carved out the inherent jurisdiction for special treatment. And as your Lordship pointed out earlier, the Section 100 wasn't aimed at this at all. It was, the inherent jurisdiction is a precious jurisdiction that the Family Division and Section 9 judges use sparingly but flexibly. And just because it's a local authority doesn't change the rules. It can't change the rules because it's still the same jurisdiction. It's still the inherent jurisdiction.
When looking at the intention of Parliament in Section 86 Act,
Yes.
it's easier to see how that might arise in a private law case than in a public law case. I know
in the family
there's things
division,
that were said in Riem we've got to perhaps look at. But,
Yes.
But just looking at the word of the statute.
but the wording of the statute.
I'm not disagreeing with you, but you understand that.
Yes, no, but I think it's just now we're looking at one where the local authority is the applicant, but it's still the same test and the same rules. The inherent jurisdiction is there, and it can be used protectively.
But the subversion issue won't it more obviously arises in a private law case than in a public law case because of the way Section 11D is worded.
Yes, but if they wanted to exclude a public authority, they could have done that and said that it only applies to private individuals. They didn't do that.
But you've also got the point about Section 100 leave being required.
Yes, but the inherent jurisdiction, we all know that day in, day out, it's used for new situations that develop, where there isn't another answer. And clearly, although the 1986 Act has not been very popular in the way that it's drafted, it clearly carved out to keep that very important jurisdiction to deal with developing situations, to deal with unusual situations. And in this case, the protection of a child who's British, the compelling circumstances of this case and the local authority's application, it's difficult to imagine a stronger basis on which to make such an application when there was no other option. There was no statutory option available for them. So they have, we say properly, invoked the jurisdiction. But the just on the point of subverting the intention of Parliament, when Ms Justice Henke, she says on the one hand the jurisdiction existed, and then later, as you've looked at this morning, she says it cuts across the statutory scheme, and we say that both can't be correct, obviously, because either it does or it doesn't. And as I say, I think that some of what's in Riem in the obiter stuff has led to confusion as to whether it is always the case or not.
What precisely do you mean by some of the obiter stuff?
Well, I can look at it, but it's outside of the main decision, which is, as I say, based on His Honour Judge Maradifer not being clear enough and not doing what Mrs Justice Lieven did, which was to put exactly what the factors were that led to her decision to give the order that was sold. On re-em, it might be good to look at that. What we say again is that the test is a helpful one, but that some of what is said obiter perhaps would benefit from clarification. So, my lords may, when you look at the judgment, you'll see Mr Gupta's submissions start, or 113, I think, is where perhaps the mischief started.
Well, you might start at 107.
Oh yes, I have.
Where I referred to what Lord Sumption had said.
Yes, the wide range of orders.
Yes, exactly.
Section 8.
And it's yes. So that's where it starts.
That's where it starts, my lord. And just while we're on our own judgment for today, Mrs Justice Lieven, I think, almost, even though that she didn't have to accept that part, she does refer in her judgment, which I've just put here. Paragraph 84. That may be a reference back to 107 in the
Yes.
So she's covering all options in my submission by saying that. So she has done everything else that she needs to do, but she's clearly taken some notice in my submission of paragraph 107 of re-em. And then, my lord, you go on in the judgment in re-em 113. You deal with Mr Gupta's submissions about why the father is saying that the order that Maradifer made shouldn't stand, and you see at 114 Mr Gupta submitted that the judge's order conflicted with section 2.3 of the 86 Act because it was dealing with A's care or living arrangements under the inherent jurisdiction. And then there's lots of
Yes.
paragraphs, and then you get to your determination, and it's clear if you just stick with the determination as I submitted earlier, it's clear from 125 that you're overturning on the facts. So in effect on His Honour Judge Maradifer's misuse or incorrect invoking of the inherent jurisdiction on those facts. And you go through three factors in particular. The second one is at paragraph 131, and then the third one at 134.
Yes.
And then you overturn him on the facts. And then, my lord, and almost unlikely ally that we find to support Mrs Justice Lieven's judgment in this case is in my submission in Lord Sumption's dissenting judgment in Re B, because he sets out from 105 paragraph 81 his take on the use of the inherent jurisdiction. And that's a part that obviously the appellants wouldn't be relying on, because paragraph 81, for example, he talks about the extensive statutory family jurisdiction based on the concept of a quasi-parental relationship between the sovereign and a child of British nationality. And in that paragraph, you can see he accepts, as does the rest of the court, the existence of the jurisdiction. And then this is the part we say supports the orders here. In paragraph 82, do you see where he talks about such orders under the inherent jurisdiction have been made, the third line.
Yes.
Two classes of case, both of which can broadly be described as protective. The first is abduction cases before the enactment of a statutory jurisdiction, and the second is where the child is in need of protection against some personal danger. For example, where she's been removed for the purpose of undergoing a forced marriage or female genital mutilation. All of the modern cases fall into this last category. That's exactly the kind of case that this is. It's about protecting a British citizen who is at risk abroad. And then he obviously goes on to talk about it not being the place. But he goes on then at 84 to say the jurisdiction is discretionary and should not be overturned in the absence of some error of principle or misunderstanding of the facts, unless the judge has reached a conclusion that no judge could reasonably have reached. Now, it was perhaps notable this morning that you weren't addressed on, other than Mr. Rowley talking about the Thai authorities, but on where she had done something unreasonable, Mrs Justice Lieven, or misapplied or misunderstood the facts. The facts were agreed, and there is no doubt on the facts that there is a significant risk of personal danger to the minor child. And then his paragraph 85, he talks about not cutting across the statutory scheme or to use subverting Parliament's intention, perhaps. And then thirdly, at paragraph 86, if there were grounds for believing the child to be in danger or some other extreme facts justifying the exercise of the inherent jurisdiction, it would no doubt be possible to have the child assessed. So it's that in my submission is Lord Sumption. Even Lord Sumption may have taken issue on the facts in that case with the child being returned from Pakistan, but this is a very different case where you have satisfaction of his three types of situation that would justify the use of the jurisdiction.
Yes.
My Lord, unless there was something else, I think those were our main points, other than sort of practical points that we wanted to.
Can I take you back to my Lord's judgment in and to the concluding sections, well, not concluding, but the paragraphs a bit further on from the ones we've been focusing on. So when the Lord deals with the reasons for overturning what Judge Radiford did, three Lord headings. 126, and then secondly 131, and then 134, and then the paragraphs after that. That's what I just like, for my part, I'd like your help with. I know you've covered this in writing, but it would be helpful just to hear what you wanted to say in the light of the discussion during the day. So, in 136, we remind ourselves that this is a private law case. It's clear from the order this was a welfare inquiry. The court was embarking on a welfare inquiry.
Sorry, do you mean in Riem?
Yes.
Yeah.
He says, and then concluding sentences in 136. An order providing for care needed to be made before she arrived here because the necessary arrangements needed to be in place. Such an order would have either conflicted with the provisions of the 1986 Act, or if it gave care to a local authority, would have conflicted with Section 100. What are your submissions on that?
Well, my lord, that is well, we say when you look at what the Supreme Court said, this is going back to the cutting across the scheme. Either an order like this is an order within the offends Section 1 and 2, or it doesn't. And the Supreme Court said this order in this case is within.
So that, my lord, there was talking about an order which would have to be made. It wasn't talking about the order which was made.
I presume so.
That's what it says.
But the order in that case was bringing the child across for a welfare assessment. There's no doubt about that. In Riem, it was to carry out a welfare assessment. On the facts of the case, the Court of Appeal said that he was wrong to find it was justified. But in terms of the law, he would have been within his rights if the facts had been right, is my reading of.
And then in 137, of course, this is, you were there. The Lord said, even if no such order is made, the purpose was to undertake a welfare inquiry, and that was subverting Parliament's intention.
Yes, I think that the Court of Appeal must have meant that it was on the facts not justified in that case, because my lords may remember that the parent who secured that order for the child to be brought from Algeria was objectively perhaps one of the least deserving applicants that ever came to the family court, because she had claimed that she was a victim of terrible domestic violence. She had tried to escape Algeria. She had first escaped the child protection system in England, gone to Algeria with 2 tiny children, and then when she was subjected to violence over there, she left the children and came back and then didn't appear again really for 8 or 9 years.
Yeah. Well, my lord does emphasise in the circumstances of this case.
Yes, exactly.
It's a private law case, and the conclusion of this court was that on that case, to do what was being asked would be wrong because it was expressly for the purpose of enabling this court, the English court, to decide who should care for the child and whether it should be here in Algeria.
Yes.
And that
Was
clearly within 11D.
Yes. On the yes.
In public law cases, I'm sorry, I'm on a crack record here, but in public law cases, the language of Section 11D is not, that doesn't apply on the language to public law cases, and you have the Section 100 filter.
Yes.
For legal
Yes.
to be granted.
And also in this case, my lady's point about the comity hadn't been covered off by His Honour Judge Moradifer, and my lords were not wanting to offend the Algerian courts, etc., which were not said to be not functioning or any of those things. But so I think on the facts of that case and on the judgment that was under appeal, not enough had been covered off, whereas in this case, Mrs Justice Lieven has covered everything she needed to cover.
And you would say that the approach that she adopted in paragraph 55 covers everything in a succinct way. You do say that.
Was that the pros and cons?
In determining whether to exercise the jurisdiction. 1, 2, 3 at the top of 181.
Yes, absolutely. The paradigm is not something that you often use on an appeal, but it was almost.
If you're responding or something.
But it was textbook what she did to identify the jurisdiction, the law, and then what's the test, and then applied it to the facts and did the balance. And that maybe is something that she has added to the REM test, is to specify in the way that we do in more general Children Act cases now, where you have to look holistically at it. And we've almost gotten there in a lot of cases, like relocation, etc., that you look at the pros and cons and you try and see what it would be like for the child in each situation. And here she does that. It's an added extra that she has imported into the REM test. So she sets out in clear terms, these are the reasons I should make the order, these are the ones I shouldn't. Overall, the risk is too great. So she does it very well in her submission.
Anything else? Anything else? No, thank you very much. Yes, Mr. Rees.
May I just address one matter? That's in respect of the intention behind Lord Wilson's
Yes.
words as a subversion point.
Yes.
And your lordship indicated that it may well be more easily understood in the context of private law cases. Please would you look at paragraph 92 of RED, which you'll find at 201 in the authorities bundle. Paragraph 92, which is found
Yes,
on page 201.
Sorry, 201.
201. And in looking at Parliament's intention, Her Ladyship just does not concentrate on the 1986 Act. She focuses as well and makes reference to sections 17 and 20 of the Children Act and its Welsh counterpart, the 2014 Act, by reference to what Parliament was setting out quite clearly as to local authorities' duty to protect and safeguard a child is based on presence within that local authority area. So in our respectful submission, if one is looking at the intention of Parliament in terms of a local authority protecting and safeguarding the children, there is further support from that paragraph to the overall contention that the basis to do so is based on habitual residence or presence.
Well, except that under the 96 Convention, the local authority could invite the court to request the relevant authorities in the other jurisdiction to transfer, or the other state to transfer jurisdiction. And the same would apply. So, can you really take it that far?
Well, I would say it does, because there is clear indication from Parliament that the local authority's duties arise from a child being in their local authority area. And that is what we say is the error of principle, which the learned judge fell into.
Any local authority, under section 31, any local authority can start make a file a care application. That section 31 defines the designated authority in whose name the order must be made, but there's no restriction actually in the Act. No requirement that a child must be resident or present in the local authority area before the local authority can start to take proceedings.
I think it's habitual residence or where the facts giving rise to the application give rise.
Well, that is the
Designation. Of course, NQJ refers to, and I've already mentioned it this morning, the observations of McDonald-J that there is similarity with the 1986 test as to the basis for founding public law applications. Lord, my lady, that's the only matter I wish to address in
Thank you.
terms of Parliament's intention.
No, anything else? We're just going to rise for a few minutes.
Yeah, I am. Okay.
It was that one, you know, she said she wouldn't go back. She just decided after 10 years in France, she'd stay here. A new test for and she said she won't go back.
As you probably gather from our interactions, I have random thoughts. Looking at his lordship, David Chow
Yeah, I do.
At least in this case, they were
So, I mean, if you
Who's the one that was up there? Was she up there? She
Yes.
was
if we have to, she wants.
Yeah.
Just if we want to be like me. Taxpayer on the lookout. Go and make sure. It's absolutely.
We're just talking about
Didn't you do a case with Ian Goldrake where he said that was your aha moment? He said, I don't do aha moment.
was he your opponent or were you in front of him?
It's a case of Chester, yes.
Kyle says nasty things all the time, obviously.
He said, like, day tenor, because the judge wasn't very fair. And very obviously, he came out of court and said, I'm going to go and kill myself. And I was like, no, please don't do that. And I was sitting in the corridor in my screen building on the floor beside him. But anyway, he only went and jumped off a 3-story building that night, but he didn't kill himself. He just like shattered his legs. And he had already made the front page of the Daily Mail.
Got my advocates means for 4 and 5, so I've wrote here probably. No, of course, absolutely. Yeah, that is true. She's kingdom jurisdiction. Yeah, sure. I think, and I'll just try.
There's no taste of cocoa. It's supposed to be it's not unpleasant, is it? And it's better than water, like if I
Did you get the details or did you get the package?
but if you're buying it at Sainsbury's, it's £3 cheaper than Waitrose. Not
Yeah.
because you can just buy Tesco organic, which is there.
Yeah, appreciate that.
Waitrose, everything is. It's okay, my son was working there. So he gets like 50%.
All rise the table.
Thank you very much for your respective and comprehensive submissions. We are not in a position to give our judgment now, but we are in a position to announce our decision, and we think it appropriate, given the circumstances of this case, to announce our decision, and that is that the appeal will be dismissed for reasons to follow. We will be sent our draft judgment as soon as possible, with the usual caveats as to its permissible use, and we would expect or hope that you will be able to agree a draft order once you've received it, but if not, we'll deal with any outstanding matters on paper. So thank you again, and that concludes today's hearing. Is there anything else?
Only this, in anticipation of the permutations, before we knew of the court's decision, and bearing in mind the time and the fact that the parents need to travel, the opportunity for them to consult with us will be limited today. So we asked of the local authority when it would be anticipating making steps that would give effect to the court's decision in the event that the court decided as it has. And we asked for some short delay so that there could be some consideration.
Yes.
I can say, if it assists, I'm sorry to
No,
cut
no,
across
go on.
that I think there is agreement from the local authority that no steps to put into effect the judgment in terms of travel to pick I up will take place before 4 o'clock on Tuesday of next week.
Well, I was going to add to that, actually, that I think it wouldn't be appropriate for the steps to be taken until you received a draft judgment.
Well, that would be infinitely preferable.
I don't think it would be appropriate for that to happen before the draft judgment has been received by you.
Thank you very much.
And then you can give consideration to any other matters and make submissions as may be appropriate.
Yes, indeed. Thank you, my lord.
Thank you.
All rise for table.